Hello viewers, I do hope that you're all doing well from wherever that you are. We have been running a webinar series on data protection in the various sectors of the economy. And a few weeks back, we had the opportunity to run one on data protection and the academic institutions, guardians of privacy. What is your role as a parent? What is your role as an academic institution? What kind of safeguards do you need to keep for all those people who are bringing in information about themselves into these academic institutions? The webinar that you're about to watch, I do hope that you're able to take away some few key points on how you can protect your stakeholders from an academic institution in matters data protection.
We'll start with the questions of the day. So just let us know in the chat box what motivated you or gave you interest to join the webinar and some of the challenges that you're facing. Just write it down in the chat box. Thank you. So we have a response from Martha Chiari, and she says that she's offered her services in the education sector for over 8 years. And also being a parent, it motivated her to log into the meeting, and she just wants to understand the data protection and how it applies to schools and colleges. I think regarding where the staff are concerned, so how data protection applies to them and the dealing with the data regarding students and staff. So far, that's the only comment we have.
So when we think about data protection, we need to have an understanding what is the legal underpinning. Why do we have the necessity of privacy? And I must point out the difference between privacy and secrecy. My mobile number, it is my private number, but at the end of the day, it's not a secret. Because if I want to communicate with you, then I'm going to be able to do that, or I'm going to give you the number. So it's not a secret, but it's a private identifier. So the Constitution of Kenya gives us the mandate to look into what exactly is privacy, and it becomes an enshrined right, just like what we have, I think, with affordable housing. So those rights are fundamental basic human rights, and privacy is one of the key elements, which is captured under Article 31 of the Constitution. And to give support to this fundamental human right, we have now what we call the Data Protection Act, which I do believe that now most of you have heard about it. You have heard that some organizations are being fined, even schools included, because in that act of the Data Protection Act, we now have somebody who is in charge, who is the Data Protection Commissioner. And for purposes of this webinar, allow me to refer to that office as the ODPC for easier pronunciation for this conversation. So the ODPC office came into place, I think, in November 2020. And then, of course, given the fact that the Act needed regulations to be able to give it more spirit and more life. And so a couple of regulations were passed in 2021. There is an organization like a school needs to be registered as a data controller or a data processor. We'll get to in a bit to the exact meanings of these terminologies. And also we had regulations about compliance and enforcement and complaints and management of complaints. But I think for the most important bit, last year, we had the Data Protection Commissioner's Office come up with guidelines for the education sector. I do recall before the guidelines came in force, I think in December 2023, then we also had, we had actually attended a training for an educational center. And one of the key questions that kept coming out from the school is the fact that now the student becomes what we call the data subject. All the information that you've been asking, majority of it relates to the student. And then there comes in the parent who is now requiring to be alerted what exactly is happening with my child in school. So the conundrum at this particular point was the school has a contract with the student because of the enrollment. And then the school has this relationship with the parent because the parent is the person who pays the school fees. So when we look at the Data Protection Act, the question becomes, to whom should we ask for consent if for instance, the parent wants to find out about how the student is faring? The act was not clear. The guidelines that had been issued before were also not very clear. And I think that's the reason why it was important for the ODPC office to come up with regulations that really touch in this particular sector of education. So 2023, now we have the regulations that touch on the educational sector. And the key questions that we would want to ask ourselves is, if we are looking at privacy from the educational realm, why is it important? Why is privacy important in the educational institutions? When you drop off your child at school, why is it important that the privacy mechanisms that are employed in that institution, or you as a parent, why is it important to understand the mechanisms that that school employs for purposes of protecting the data that you've given them about your child, or even yourself as the guardian? So number one is the preservation of privacy. So as I said earlier on, we have now moved into a digital realm where the complete nexus between online and the learning ecosystem are almost now one. And in the preservation of, in the collection of information about a student, be it the application is online or be it the application is manual, you have to literally go to the school, there is a trove of information that has been obtained from you as a parent or from the student. And this information, the schools are now the custodians of this information. So at the center and heart of it all, there is student data. But I want to point out and say that data in schools is not only about students. So there is the staff members, there is the partnerships that probably an institution has, there is the, I think one of the participants talked to us about being in the ECD forum, I think a school. So you also have other partners or other schools that are not within this country. So it is important to understand that now we have become custodians. As academic institutions, we become custodians of data that belongs to other people. So it is important to have that responsibility that you, as the guardian of that information, you must ensure that its confidentiality is maintained. We will look at what are the repercussions if that does not happen. Number two, one of the other reasons as to why we need to look into privacy from an academic institution is we are building trust. We do not want a scenario where we have given you our children's information, or me as a staff member, I've given the organization information and then I find it elsewhere. And we have been through court processes where we have seen at even the court, the moment you start using somebody's image without their consent, that comes with a fine that is going to be attendant to the organization. As well, we have also seen schools that have been fined for using image rights, something that has been entrusted to you as a custodian of that information. But for some reason, you've decided to use it as a marketing tool. That again is one of the reasons why as an educational institution, you must embed privacy within the organization. Of course, there are legal and ethical considerations to be put into place. The act is now in place. The constitution is now in place. And one thing that I keep saying as a lawyer, when somebody moves to court through a constitutional petition, the damages are much higher than what probably the Data Protection Act would give as a fine. So it is always important to adhere to this consideration that at the end of the day, legally, as an institution, compliance is key. Of course, it also helps to enhance cybersecurity in educational environments. There is a student who has logged into the platform using, I don't know, a mobile. There's a lecturer who has logged into institutional platforms, I don't know, using what other devices. Basically, there is a whole trove of people connecting probably to an academic institution's platform. So if we are able to identify what are our areas of weaknesses, we can be able to enhance cybersecurity with these educational environments. And out of context, but in the same realm, we do remember what happened when eCitizen went down. And then there was all these hula baloo, we can't access our services, etc., etc. So it is important to always be on the lookout to be able to enhance cybersecurity. So of course, there are numerous reasons, but I would want to cap it all and say that having a great or compliant data protection when it comes to you as an educational institution, it also gives you an opportunity to be able to have personalized educational or learning mechanisms. So if that information has been entrusted to you, it is a plus for the school, but at the same time, can you be a great custodian of this particular data that has been given to you? So to give us a bit of context, it is important to understand some basic definitions that are captured within the Data Protection Act. And we will get to this as we move along, we will get to see how this applies within the educational sector. So if you are new to data protection, and if you have had an encounter with data protection, please allow us just to go through these key definitions for purposes of people who do not know some of these terminologies. So a data subject is a person who is identified or is an identified natural person. So that could be me as a staff of an organization, which is a school. That could be me who is a student in that particular school. That could be me who is the vice chancellor of that school. That is me as a supplier who is operating on my own self. So any information that you have about an identifiable natural person, that is the person that we call the data subject. For personal data, this is information relating to that person. So that information could fall into two categories. It could just be personal data, or it could be sensitive data. In a school, for instance, I remember during my heydays, we had these students who never used to eat githeri. I'm sorry if you're not Kenyan, but githeri was the staple food for a lot of schools. I don't know whether that's still the position today. So we had these students who would bring their medical reports and say that they needed to be on a special diet. And that information, that medical report information, that is sensitive data. So data can either be personal or they can be sensitive personal data. So medical records, biometric, issues to do with your belief, your conscience, your sexual orientation, all those are personal data, sensitive personal data. When we talk about processing, processing is whereby operations are now performed on the data that has been collected. That could be through the collection, that could be recording, organizing of the data, storing it, reviewing it, disclosing it, or destroying it. So that's the whole process of how, when you hear data is being processed, that is a whole picture of how that looks like. So we also have the terminologies of who a data processor is and who is a data controller. So a data processor is basically somebody a data controller is somebody who collects the data and determines the purpose and the means of processing that personal data. So a school is a data controller. It can also be a data processor if it's just processing data on behalf of somebody else, maybe a research institution, etc., etc. And then in the realm of the educational sector, it's important to understand who is an educational institution. So the guidelines provide that any organization that has established itself to provide educational services to students is deemed as an educational institution. And then there is also the element of stakeholders. So where do parents lie? Parents as guardians or people who are in charge of the students. All those people are ecosystem stakeholders. That could look like the Ministry of Education, that could look at governmental institution. All those people are stakeholders in the realm of data privacy in the educational sector. To help us understand data protection, there are some key principles that must be abided by. They form the foundation of data protection. And even when you draft, for instance, our data protection privacy policy, you must ensure that you're able to capture these principles. If you are running a website that is probably onboarding students from an online platform, you must ensure that you abide by these principles. If you're getting data that is needed to be given either from yourself as an academic institution to another organization, you must again fall back to these principles. So just in a brief highlight, these principles are about 6 of them. There must be an element of lawfulness, fairness, and transparency. When you collect the data, why are you collecting the data? For what lawful reason are you collecting the data? Please do not just collect any data for purposes of collection. I think those old days are now behind us. Make sure that you're collecting it in a fair manner. It's not a question of coercion. It's not a question of making this as if it's a matter of life and death. Why do you need to ensure that you have it from a fairness perspective? It is important, because at the end of the day, when it is proven that you did not collect the data from a fairness perspective, then it becomes a nullity. And of course, again, we're going to go to the repercussions of why that should not be the case. Number 2, we also have the principle of purpose limitation. Why am I collecting the data? For what reason? Am I collecting the data for research purposes? I need the student to undertake, to be part and parcel of as a subject for research purposes. Why am I collecting it? Or am I collecting it for, once I've collected it from a format of research, I'm also using it for other purposes? That again is against the law. Data minimization, so you collect only what you require. Don't collect too much. And I keep giving a very great example on this particular principle. Some time back, there was a matter that was filed in court, I think by the workers of Kenya Power. So one of I think there was a transition, I don't know from what to what, I can't remember correctly. But what struck out for me was the kind of data that they were being requested for was in the sense of, where do you live? Who are your parents? Can we get their numbers? Can we do all that? So the question becomes, as an employee, how much data does an employer require? Do I need to tell them that all the houses that I own are here, in Kamulu, in where? Do I need to tell them, other than the basic minimum requirement of dependence, do I need to tell them so much about myself that even where is my cat or where is my dog? I do not need to do that. So the other principle is accuracy, ensuring that there's accuracy when it comes to data protection. The correct data that you've collected is correct, and it is not, and we'll see as we move along that it is that the data subject has a right for rectification. So ensure that you collect them as much accurate information as possible. Excuse me. In terms of storage limitation, for how long are you going to store the data? Do you need to store the data for 5 years? Do you need to store the data for 3 years? I would like to hear from you, the participant. For how long have you been storing the data? And especially when it comes to matters students. So me, who was a student in perhaps Nairobi University in 1985, are you still storing my data in its raw format? Are you still doing that? Do you need the data? I think there are some practices when it comes to some professions like the HR, it's about 5 years. For us as lawyers, it all depends on the kind of matter that we are handling. For land matters, it can be as long as 20 years, depending. For contract issues, it can be as long as 6 years. So there are certain statutory limits that give us guidance of to how long we can store these matters. So moving on, I would want to just highlight what are the legal bases for processing personal data in the educational sector? Why do you need to process data? And why, and what rationale or what legal underpinning would give you that authority to actually do that? So number one, we have the consent. Of course, I like what the parent asked. I need to understand my rights as a parent. If I have not given my consent for image rights or images of my child to be utilized, then why are you doing so? Why are you actually doing so? So this consent must look in the format of the data subject, who is a student. If the student is a minor, ensure that the guardian has already given you the consent. And then the another legal basis for processing of data is also the performance of a contract. So admission to the school is a contract. Without it, as I said, the contract is almost like a tripartite contract, because we have the data subject who is a student, we also have the guardian or the parent who is also part and parcel of that contract. So the performance of a contract, it enables the school to give you the service of the academic, it gives you the service of the school in terms of education for your child. At the point of also staff members, when they're being enrolled into the organization, this is also another performance of a contract that is allowed under the law for you to obtain any data. And then compliance with any legal obligation. And from here, I want to look at it from a perspective of the government, for instance.
So yes, so the legal basis for processing of the personal data, I think we've already touched on the consent. We have already touched on the performance of a contract, compliance of any legal obligation. Of course, is also the protection of vital interests of the data subject. I don't know, I probably want to throw this back to you. One of these elements of vital interest is when there are government mandates in the educational sector. Is payment of school fees through the governmental number a vital interest of why data would be required? I'll throw that back at you. And then, of course, we also have the performance of a task undertaken by a public authority. For instance, if they need to take any sort of information to KRA, if I am a staff member of an academic institution, that would also look like that. There also must be what we call the legal basis of legitimate interest. So in the case of an institution like what one of the participants highlighted, are you doing research? Are students part of the research? Are you giving the consent form so that they can consent to them being subjects in that research? Ensuring that even if you do that, consent is still at the heart and center of data protection. And of course, we also have, when we are talking about historical or journalistic literature, I think as a parent, someone asked that, at what point do we give out the information for purposes of scientific research? Did you ask the consent of the parent? But if it's probably in a journalistic sense where we do not have to identify somebody in particular, like a student or a staff member, then that will be okay within the data protection realm. So again, just to rush through, what are the basic rights of the data subject? Yes, Luis, the recording will be shared. What are the basic rights of the data subject? What are your basic rights as a staff member of this organization? What are your basic rights as a student in this school? So number one, of course, that the information to which you give, it is being put to the particular purpose and use. Access is important. Access is important because if, for instance, I want to rectify or correct or seek a request for deletion, I cannot do so unless I have access to my information. If I'm objecting to any particular, issue in terms of how you've processed my personal data, that is also my right. Correction, deletion, and no automated decision-making processes. How does no automated decision-making processes operate in an academic institution? So in a bid for efficiency, we'll find that we have either onboarded certain applications, certain software that can either deduct or deduce that maybe a particular student might be more favorable to a certain element of the school, or their data is speaking to a certain kind of way. Either they're not faring too well or they're faring too well. So if there is an application that is enabling that to happen, there is need for an intervention of the human. Now, with the advent of artificial intelligence, we can almost not tell what is what. But you see, if we subject a student or if we subject a faculty member to an automated decision-making process, it works on the data that has been fed to it. But me, who is a human, I can either sitting at a HR perspective, I can be able to look at a scenario and see the facts may look like this, but given that the person also has made amends, this needs to be corrected. We had talked about transfer of data overseas. So as we understand the rights of the data subject, any organization that is also transferring data outside of this country, whether that be Tanzania, whether that be Uganda, it doesn't matter. So ensure that there are safeguards in that country that you are transferring the data to. The safeguards are for really the protection of any misuse of that information. May it reach Uganda and it is misused in a certain way. One of the key things that the Data Protection Commissioner is always looking at is that country, in that other jurisdiction, do they also have their own laws that they have put into place, that even if the data has been moved to Uganda, that we do know that Ugandan data protection is going to apply. So for instance, a country like Uganda, it already has a data protection law. Tanzania, I think, was one of the newest newcomers. I think they got their laws recently, I think last year, towards the end of last year. So ensuring that as you undertake the legal and ethical concerns when it comes to data protection, the other country has adequate safe measures. One of the things that that comes to the fore when you think about transfer of data overseas is the fact that sometimes as data controllers, we also have employed data processors. If, for instance, today I want to tender for a service, now we have given TenderSure that authority. For the school, we have already given TenderSure that authority that if we want to tender, we're going to tender through their platform. And then we say, because TenderSure has also a branch in Uganda, we can also transfer the data that we have received also from a Kenyan company here and transfer it to Uganda. Probably they also have a subsidiary in that country. There must be a nexus between you as the data controller. What are the legal agreements that are binding you with the data processor, such that if anybody was to come back and investigate? Right now, I think I'm made to understand that the Data Protection Commission is actually undertaking audits. It comes to your organization as a school. It looks at how you've been undertaking your legal and compliance matrix. Are you transferring data outside the country? So it is important to always ensure that any data processor who is undertaking work for you as a school, who is a data controller, you are able to put in some legal relationships between yourselves and any data processor. How would information be breached in a school setup? So number one of the ways that this could happen is through availability of breach. By this, we mean examples where there's loss, information has been lost, there's accidental and unlawful destruction of that particular personal data. And then we also have integrity breach. We all know that there's somebody either in an organization who does not follow the rules and for some reason has unauthorized access to personal data that does not belong to them. A question has always emanated, is HR, I remember we went for training in a certain organization, and when we were training they have various centers within the country. So all these centers, I think about 47 of them, we were all congregated at this space. And one of the complaints that emanated from that was the fact that, is HR allowed to share my data with another staff member? Are they allowed to do that? Absolutely not. Because how much I earn or if I'm unwell should not come into the purview of somebody else who I'm working with. That is information that I've given the organization, and it is in the custody of the HR officer. Confidentiality breach, unauthorized disclosure or access to personal data. This can be through sending data to wrong recipients, failing to follow stipulated security policies. If you do recall, I think there was a time when we had a case in court about, I think it was what is this ministry? The devolution ministry, I guess. And then there was this issue about authorization or access to the IFMIS system, where you find that the staff are either failing to follow the policies that have been given, or employees are attempting to, have unauthorized access to that particular data, etc., etc. So another way that there can be a personal breach is the fact when some phishing attempts have been directed into a particular organization. I know last year we had the NIVAS issue, and they did report to the Data Protection Commissioner that there has been malicious attempt on their systems. And I think there was also, I think, a shutdown that had occurred, but they were able to come back. You must report that there is a data breach within your organization, and there's a timeline, which is 72 hours. And if you cannot be able to give that information within the next 72 hours, it is important for you to inform the data commissioner that we are not going to, manage to report. Oh my, what is happening? We're not going to report, we're not going to be able to report this within the speculated timeline according to the Data Protection Act. If that does not happen, unfortunately, I think there is an element of sending a strong message. There are fines that are payable if you do not report. Then again, if any of the breaches occur, whether inadvertently, whether by design, whether by default, that student at this school that was called Roma Primary School was fined 4.5 million for posting a minor's picture. So for whatever that reason happens, you did not get the consent, so there was breach, you did not get the consent of the data subject, either the staff sent to the wrong recipients, I don't know, all those things that we have highlighted before. If that happens, the ODPC has the power administratively to actually issue fines and penalties. Of course, that does not remove the aspect of court as a place where you can get legal relief. You can also go to court. I do believe that before these fines, we started seeing these fines from the ODPC, I think last year, where we saw there was this for the Roma Primary School. There was also the digital lenders. I think there was also another one for restaurants and bars. Some matters had already been taken to court. I do remember there was an image right breach by a certain university in Machakos. I think it was called Technical University or something like that. So it doesn't negate the right for you to go to court and actually seek for a specific penalty for somebody who has breached. So what are your obligations as a school? You as a stakeholder, what are your obligations? Number one, I keep saying it is important. You must have some policies that guide data protection in your organizations. And these policies not only give the guidance, but they notify the data subject what is their right. We have captured part of their rights in the previous slides. What are their rights? So ensure that as an organization that you have privacy policies. We are now getting to a point where most of the applications when it comes to especially tertiary education is now online. Do you have privacy notices on those websites such that any information that is being keyed either by a parent who is on this call or either by a student, do they know what happens to that information that you have given them? Do you have a privacy notice? Number two, it's also important and as an obligation to you, a legal one and an ethical one, that when you're processing sensitive personal data, please do let us know. And that's why I've repeated, a lot of this is cured by you having what we call standard operating procedures. But in this particular aspect, privacy policy documents. And also from a HR perspective, have you interrogated that an element of data protection has also been captured in that HR policy of that organization? So when you're processing this sensitive personal data, why are you asking for the data for? For what particular reason? Have you obtained the consent of this particular data subject? Have you put in measures to protect this data that you've collected? For instance, we have what we call pseudo-anonymization. When I send you M-Pesa, you first of all know all my government names. That's number one. Number two, I think now I don't know whether they have put in that place, but I can also see your number so that I can tell whoever's number is. This one is Muthoni Njogu, number of this match. And you only need to piece a few things when people are getting to what we call identity theft. I only need to piece a few things from you. and people share a lot online. So are there measures that even as the school is getting all this information, are there technical and organizational measures to protect it? Elements like pseudo-anonymization. How much data do I need to understand about Muthoni who left in 1995 that I still have their data? Have I anonymized some elements about their data? If I've been keeping the data for this long, have I done that? Number 3, ensuring that personal data, when you're sharing any personal data about a student, about a faculty member to any organization, be that be KRA, be that be NSSF, be that be NHIF, be that be the Ministry of Education, ensuring that as well, even if they're a government entity, that they also put in place, strong technical and organizational measures as well to protect that data. Somebody asked the other day, has the ODPC started doing audits on government? And there was an insinuation that sometimes government is the biggest, it's a weak point when it comes to data protection. But they were happy to also confirm, I think somebody else also confirmed that indeed the ODPC is also carrying audits when it comes to government authorities. Because if we are talking about a law that is applying to educational sector, it is a law that applies to everyone, government not excluded. As well as an obligation for you as a school, it is important that you embody privacy by design or privacy by default. So we'll get to to explain exactly what that is, but allow me to also just chime in to say that another obligation for you as a school is to ensure that your child, you have put in data protection considerations for children. One is their parental consent. Please do not share any of their images. Please do not share any of their content in newsletters if you've never asked for any single consent from that parent. So then again, it goes back to how you enroll these children. What are your documents looking like? At what point do you enshrine data protection in all those admission documents? At what point do you enshrine data protection measures in the employment contract? At what point do you enshrine data protection mechanisms in the internal policies of the organization? How does that look like? They'd also need to verify the authority of a parent or a guardian. As a lawyer, I will say this, given the fact that we have dealt with a bit of children matters, you will find that there's a whole legal, I do not want to call it a mess, but there are various rights when it comes to children. And you will find that either the child is being adopted, either the child is either adopted by family or adopted by somebody else who's not a member of family, or they're now living with a relative, or these are the actual biological parents who do not live together. So there's a lot of gaps that need to be filled when that verification is required. So as a school, please ensure, have some level of verification. For instance, if a child is actually adopted, ask if there is the adoption papers. Do they have the adoption papers for this particular child? And of course, there's also age verification. I will get to all your questions as we are about to wrap this up. Also understanding the age verification and also putting in place child controls. And especially now we have a lot of applications, even for the junior level. I don't know, Soma app, I don't know what app, and this manner of apps. So are there controls that you've put in place? Just the same way we put controls for Google, and so there's kids for YouTube for kids. But in my honest view, I think the ideology of kids, YouTube for kids, our African setup has different ideologies as opposed to what the makers of that platform have in mind. So it is important to always put controls, and especially when you have onboarded children into apps that make either the student-teacher interaction much more easier. And of course, if you're publishing any exam results, this has been the norm in this country. We need to know who has attained what grade. Please ensure as well there is a sufficient parental consent, again, in application to taking of images. So what are you looking at as an academic institution? If you were to look at the key privacy documentation document, what would you be looking at? There are many, but it also depends what kind of a school or an education institution that you're running. It could be at kindergarten level, it could be at tertiary level, which is much more, can I say, more complicated because there's so many elements to look into. So some of the key privacy documentation that any organization will need to look into is things to do with notice. I think I'd already talked about that, the privacy policy. What are the transfer register? If, for instance, you have your school in another country, what does the security policies look like, the data retention policies? Why do I need information about Muthoni since 1983 or 84? Data sharing agreements, you have your data processors who are processing information on behalf of the school. It's also important to understand that if there is so much sensitive data that is being collected by the school, do we need to do what we call a data protection impact assessment? It's very important. We also need to look at consent forms. How have you worded your consent forms? Do they protect you or they do not? Or they don't protect you? You also need to understand your record of processing activities. If, for instance, if I look at it from an enrollment perspective, who gets to touch what at what point? If the audit by the ODPC is being undertaken, can I provide a clear map of how that looks like? So I've just highlighted a couple of things that you may want to look at. There are risky hotspots for schools, records, HR, the key business activities. There's also the IT systems and third-party contractors from the business perspective now. You'd want to look at how that looks like from your point of view. So what are the measures that you can actually put into place to curb some of these things? The other day I saw an interesting element where somebody said IT can never be a data protection officer. A data protection officer is a person who looks at the organization from what we call an ombudsman view. An ombudsman, if you've ever heard of this concept, is somebody who is a neutral element within the organization. So they are not attached to management, they are not attached to the staff members. They can collect all manner of complaints, either from the staff, from the management, from outsiders. So they have this neutral element about them. And once we start allocating internal staff members and giving them, because you are the IT guy, you just deal with data protection, I think would be missing the mark when it comes to that. So data protection officers can either be internally or externally. For us, we are external DPOs for some organizations, which we help them just to be data compliant. Again, we have talked about the data protection impact assessment. If there is the likelihood that there is a very high risk from whatever organization you're coming from, it is important to do a data protection impact assessment. And of course, understanding what we're calling now the data protection by design, that the measures that you've already put in place, they can forestall or safeguard any interest. And we also have data protection by default. Already the systems that you already have, how can you include some elements to be able to protect data that comes to you from either the students or by third parties? Just a minute. As I wind up, I would want to say this. For you to build that effective data privacy program for your school, ensure that at least you have a DPO. This takes care of a lot of the headaches when you're thinking about compliance. Ensure that you maintain personal data registers. That's why I said, if I can look at your record of processing, can somebody do an audit and see this information moves from here, goes to there, we record, it looks like this. Can somebody do that? Ensure that, as I said, at the heart and center of data protection is the aspect of consent. Please do tell the data subject what is the purpose and seek their consent for that. Notify breaches if that happens. I'm not going to be able to go through the whole of it. And then lastly, communicate your data protection policies, practices, and processes. And always train. We do a lot of training for clients because at the end of the day, we keep saying this is the core function of legal to help you be abreast of what you're doing when it comes to matters data protection. And with that, ladies and gentlemen, I will stop sharing my screen. I know it's now 10 minutes to 4, which is way past our time, and dive right into the questions. So, Lois, you asked that if we could kindly share the recording and slides be shared of the session. that will happen. We do have, when we do record this meeting, we normally place it on our YouTube channel. So we, as part of the people who have onboarded for this particular webinar, this will be made known to you via your email address, just the same way you registered. Has the ODPC created data privacy awareness enough to warrant audits? I would say it's, the question again becomes, what is enough? What is enough? I do know that efforts have been made to really sensitize Wanjiku or institutions like yourselves or parents like yourselves for data protection matters. It may not be enough. In fact, there was the idea that a lot of this data protection is happening in Nairobi. It's not even happening elsewhere. It's just happening in Nairobi. So going back to your question, is what they have done enough? I do believe there's a lot of room for improvement. I do believe stakeholders like Njogu and Associates also help to bring this information to the masses, just to help understand what are your rights, what are your obligations, and what happens if you do not follow the law as is required. So I do believe, Boniface, that a lot still needs to be done, and it's been done. We must give, I'd say, let's give the devil his due. Recently, the Data Protection Office has now moved into branches within, I think, Kisumu, Nakuru, Mombasa. So they are really trying to decentralize this aspect of data protection as opposed to really be just in Nairobi. So I do know that a lot is happening, but I confirm that a lot also needs to be done. So Martha, you ask if allowed, kindly share with us the presentation. Absolutely. So that's the document. Could you also share the recording? Okay, great. Boniface, you also asked a question. As a guardian of privacy, what are the mitigating measures but in place to help legal laymen to navigate through data privacy policies full of extensive legal jargons, so complex to comprehend? First and foremost, I want to take responsibility as lawyers. Sometimes we have been the culprits of drafting things that are in so much legal jargon, so that the end result or the end output of what we're trying to mitigate may not be met. Because instead of putting a privacy notice in a language that is so easy to understand, the school as a guardian, you're not able to understand. You as a parent who's also trying to protect your child's rights, you're not able to do that. So basic thing, number one, the mitigating measures, I want to say it this way, and it depends on which divide that you are on. As a parent, if I look at all the touch points of data for my child, I can actually do that. The key question becomes for me is understanding that all the information, nowadays I know some schools have now started understanding the importance of data protection, and especially coming from the Roman example. They have now started putting into place data protection clauses within their onboarding processes. As a parent, when photos are being taken so nicely in the school, there is a concept called sharenting. Sharenting is an aspect of privacy whereby you share too much about your child. You really share too much. From the time they were at diaper level to the point where they are now grown up, probably they have gone to campus and all manner of things. So sharenting is something that is done by some parents who prefer to do that. So two aspects come out from there. Some parents don't do the sharenting. You'll never find their children online, but then the school takes the prerogative without the consent of the parent and posts these things online. I do believe we have now completely fully understood the element of consent. It must be there. Now, just on the second element of sharenting, there is now the children themselves are now taking the parents to court and saying, I was a minor. I couldn't have given you the consent to share all my life from when I was in your stomach all the way to campus. You have been sharing it. And as a minor, you are not supposed to do that. So there's a double-edged sword when it comes to that. So from a parent perspective, ensure that consent is a key element. I know that I've been to a school where when they were taking photos, there was a line, there was a somewhere where they were noting, a parent says, yes, I want my photos to be shared. Others are saying, no, I don't want my photos to be shared. So if you were not on that list, then it was evident that they did not want their photos to be shared. So as a layman, key consent, 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 consent. I have tried to read a couple of privacy notices before this webinar to see the legal jargon in most of these things. Some actually don't have legal jargon, some actually don't. It's just saying that the data we're going to collect about you is going to be used in XYZ manner. So are there complete mitigating factors if legal jargon is utilized? I would say talk to a lawyer. Again, that would be a cost element so that at least you're able to protect yourself. But this is how I look at it. Sometimes, even when clients give us the contracts to look at the very beginning and initial point, you think that it's full of legal jargon. We have now moved, and I know there are lawyers on this call, we have now moved from using a lot of even the Latin sort of conversations. A lot of it is just in plain English that we're just trying to communicate this should happen. So I really don't have a complete answer for you, Boniface, but I do believe as a parent, consent is key. When you're trying to go through the legal jargon from any other aspect, whether you're an institution, maybe procure the services of a lawyer. With that, ladies and gentlemen, I do not see any other question. Oh, Boniface, you can just unmute yourself, by the way.
Yeah, good afternoon, or is it good evening, everyone? So, like me, I have a real concern because the people who find themselves on the receiving end may not be parents, but schools.
Yeah.
And, you know, at some point, we normally throw across concepts, and some of even those people who are at the helm or at the leadership of these schools just get wondering, what do we mean when we talk about data pseudonymization? What do we mean when we talk about data anonymization? And these are some of the key practices that we use to for privacy of data. You see, when we talk about data privacy, you cannot divorce data privacy, the legal aspect, from the practice of anonymization of data so that you protect the data subject. So I really do not understand how this gets to happen so that people really understand their obligation, because most of our obligations are on paper, but how to get to really put your fingers on it and do it, I think is where the schools will really have a hard time to go by. I think we need to look for areas of just capacity building these schools so that even if we want them to understand their obligation, we should help them understand how to comply, because you cannot comply to that which you do not even understand. That is my feeling as a data practitioner, and who always want to protect data subjects. Another thing has always been, like, in our country, we cannot say that we have a shortage of laws to govern anything around us. But the question has always been, when we have these laws, how do we make sure that these laws are complied to, that compliance aspect? How do we even make the public aware of the existence of some of these laws? Yeah. So, and the technology is here with us. Like, when I see you as a guardian of privacy, can we think of coming on board and just taking advantage of technology, come out with something to do with the chatbots that we can share with these schools, where the law has been explained so well that they can understand. They can query the chatbot and then get to understand, so that while processing this data, especially for the minors, they understand what consenting is all about. At some point, I visit even the national schools we can have around us. You go there and you are told, register. And on the registration sheet, they want you to provide your names, your ID number, your phone number, where you are coming from, your tribe. You see, those are sensitive data. And you are like, why all this? And they are not even telling you why you are registering. So that they tell you, if you do not register, your child will be sent home. Is in that coercion? Is that consent or is that coercion? Thank you.
Coercion. So thank you so much, Boniface. I do believe that an element of data protection is not only just the legal part about it, but also the technical part about it. And especially when we talk about compliance. For instance, you've given an example of the anonymization. So you're saying you are supposed to anonymize your data. Then you leave that client or wondering, how am I supposed to anonymize your data? So it's a field that encompasses both the legal and the technical, such that we are working to give a school a wholesome solution to their problems. So I think it's a marriage, as you said, in terms of the technical bit. Does that look like chatbots? That could look like that, or does that look like, for every school that is trying to comply with data protection, working hand in hand also with the technical person, so that they can also see the technical aspects about it. Interestingly, I like what you said about the data that is being requested for. Interestingly, when you want to go to the Office of the Data Protection Commissioner, there is a guard there at the gate that's asking you for, that information. They ask you your name, your whatever. Does that mean the law is not in existence, such that even the Office of the ODPC still has that system still complying at their premises? It's going to take a while before we can get to full compliance levels, I think, in this country, where all that is streamlined, because that is an oxymoron, that the custodian of all this information in terms of the law and how they are supposed to ensure that the law is followed, still practicing the manual ways of collecting data, which is unnecessary in some extent when it comes to security matters. You are right, there are no shortage of laws. How do we make this much more aware to the public? I would be happy to also co-collaborate. We can also do another webinar. I would be happy. I say, as they asked in the good book, the good book in Moses was asked, what do you have in your hand? So Njogu Associates has a role to play. Boniface has a role to play. The Office of the Data Protection Commissioner has a role to play, because when the fines come, they'll come and meet the schools that are either on this call or the schools elsewhere. So we can also try to do our small bit when it comes to awareness. To completely give the mandate of awareness to a government institution, I have had the privilege of working with the government to some extent, and it's almost really impossible. So I do believe that everybody has a role to play in the ecosystem and not leave it to the regulator. Any other comments from the other participants? Any other comment? So thank you so much, ladies and gentlemen, for being part and parcel of this particular webinar.